thank you. I thank you for the kind words. The American Society of International Law is honored to partner with the Center for International Law and Policy in Africa and the International Nuremberg Principles Academy in presenting this International Criminal Court Colloquium series. I'm especially pleased to share the stage today with Dapo and Matiandai and Meg and Charles, all of whom are active members of the Society. And I'd like to express my appreciation in particular to Professor Jallo for bringing us together to discuss these timely and important issues. It's been a privilege for us to collaborate with SILPA on this important series and on other joint projects. Since its founding, the Center has really become an indispensable part of the community of civil society organizations that devote themselves to the research, policy, and practice of international and regional law. Under Charles's leadership, it's making its mark on the field by fostering the inclusion of diverse voices and perspectives from across the continent of Africa in the shaping of international criminal and humanitarian law. With the transition to a new prosecutor, the ICC is at an inflection point. As the title of this session suggests, we see an opportunity now for a reset certainly in the court's relationship with African states, which will be the topic for today, but also with countries around the world, and in those particularly including the United States, which has had such a troubled relationship with the court from its inception. For such a reset to succeed, those who count themselves friends of the court must be willing to acknowledge its shortcomings and to support constructive efforts to address them. At the same time, we should do what we can to defend the court from unjust criticism and to help rebuild confidence in its ability to carry out its mission. That was the impetus behind the report of the Society's Task Force on Policy Options for US engagement with the ICC, published earlier this year, in which Charles played such a valuable role as a member of the advisory group. And if I may, I will just post the link to that report so that everybody can have a look at it. On behalf of the Society, I thank SILPA for organizing this colloquium, and I look forward to hearing from this wonderful panel. I also look forward to our continued work together to strengthen international criminal justice and accountability in Africa and throughout the world. Thank you very much.
Thank you so much, Mark, for your kind words and thoughtful opening remarks. I'd like to now invite Mr. Klaus Rachweitz from the International Nuremberg Principles Academy, where he's the director, to give opening remarks. And like for Mr. Agras, let me just properly introduce him. Mr. Klaus Rachweitz is a German jurist, studied law at the University of Cologne, and upon graduation was appointed as a judge in 1990, where he presided over criminal and civil cases at courts of first instance and at courts of appeal. From 1996 until 2002, he worked at and later headed the Division for Information Technology in the Ministry of Justice of North Rhine-Westphalia in Germany. He was also part of the advanced team of the International Criminal Court in The Hague in 2002, so was there from the beginning, and subsequently served from January 2003 until 2011 as Senior Administrative Manager in the Office of the Prosecutor. From 2011 until 2016, he was an Administrative Director for Eurojust, the EU's Judicial Cooperation Unit, which supports the EU member states in the fight against serious cross-border crimes like terrorism, cybercrime, trafficking of human beings, and other serious crimes. Klaus, as we discussed earlier in the beginning, just hosted the 2021 Nuremberg Forum, which was quite excellent. And it's a privilege to have you here, Klaus. So I invite you to give your opening remarks.
Thank you, dear Charles. And the privilege certainly is mine, and the pleasure as well to act as a co-host and co-sponsor of this remarkable event together with SILPA and Azel. It is really a pleasure to be here today. And I'm looking forward to today's discussion on a very, very important topic, the relation between the International Criminal Court and Africa. Well, the Nuremberg Principles that were adopted by the International Law Commission in 1950, of course, do not mention and do not know any regional borders or cultural or legal system borders, but they remain as principles, and that is actually the starting point for all our work here in Nuremberg at the Academy. It's the fight against impunity, and it's giving back some dignity for the victims that motivate all of us. And in principle, it is regardless whether these cases are pursued in Africa and other areas of the world. However, it is undeniable that at the moment, every person that has been charged or stood before a chamber of the ICC is of African origin. And this certainly raises questions, and it's good that we discuss these questions. And it's even better that the arrival of a new prosecutor, I think, offers also a unique chance to reset the scene. To some degree, Fatou Bensouda, the second prosecutor, was of course already involved since the early days, being the deputy prosecutor for 9 years before she was elected prosecutor. But now, for the first time, actually, we really have a fresh start, and we will see also new deputy prosecutors, whether one or two remains to be seen, to enter the field and to enter the areas of discussion. But the relation between Africa and the ICC certainly is a specific one, but there are also elements, I think, that give rise for concern, and I'm pretty sure we will touch upon them in the discussion. The request for partial or temporary immunity for heads of states, for instance, is a clear contradiction of Nuremberg Principle number 3 that excludes any special treatment for these people. And this is a request that was voiced by African states, and that is worth to be discussed. Now, I'm very much looking forward to this distinguished panel and to their reflections about that. The International Nuremberg Principles Academy remains committed to support anyone's fight against serious core international crimes, regardless on which continent in the world. And thus, our commitment to support also Africa remains completely unchanged. Thank you very much, Charles, for organizing this, and I'm looking forward to great discussion. Thank you.
Thank you so much, Klaus, for your thoughtful opening remarks as well, and welcome to everyone. Let me just very quickly, on behalf of SILPA, also thank, of course, Mark and Klaus for the collaboration, which has been quite exciting. And this is, of course, the third in a 4-part series that we're calling the International Criminal Court Colloquium. The first one, of course, addressed the issue of the ICC selection process and a post-mortem. The second one focused on the work of the OTP, and Klaus mentioned Fatou Bensouda, so some of the achievements of the prosecutor from the Gambia, and then also some of the incoming challenges, the challenges that remained for the incoming prosecutor, Prosecutor Khan. And this third event today will be focusing, of course, on the possibility of a reset of the Africa-ICC relationship, and we'll be getting into this detail, hopefully in the substantive discussion momentarily. But let me just flag that there will be a final event probably towards the end of November that would focus on the ICC review process, because Mark mentioned the review process earlier, where effectively I think states are now taking on board the idea that not all is well, and maybe the court should look at what it can improve. So stay tuned for that final event as well. Just very briefly in terms of SILPA, for those of you, because we're a new organization, we are aiming to be part of that conversation that will bring research, policy, and practice on issues of international and also regional law in Africa, taking as a point of departure that when you have peace, stability, and security challenges, the rule of law is part of that. And of course, at the regional as well as the international levels. The center itself is based in Freetown, Sierra Leone. And we have a focus on international criminal law for obvious reasons, or of course, the obvious reason that it's an important area for African states. So if we're working on issues of international law, then we would, of course, attend to that. And we're very grateful to the Open Society Foundation, which has been one of our partners on the Africa-ICC Colloquium series, but also for funding some of our other projects on the Africa-ICC relationship. I know that Professor Sirleaf will introduce the subject in a moment. But let me just highlight very quickly a couple of points that in a way echo what you've already heard before I turn it over to Matiangai to steer us through the discussion. The first point is, why is this important? Well, of course, for those of us who've been following international criminal law, the relationship between African states and the international criminal justice system has always been obviously critical. African states were there at Rome when the negotiations were happening and took some really, really strong positions in favor of an independent and strong tribunal in circumstances where there were different ideas on the table, including proposals from the International Law Commission. We also know that African states, if you will, were quite there leading the charge in the move towards 60 ratifications, with Senegal in 1999 becoming the first country out of 120 signatory states to ratify the Rome Statute. I find that quite symbolically important, and it signaled in many ways the view of African states towards the importance of the idea of a permanent international criminal court. In fact, if you go back to the records of the Rome negotiations, Professor Tia Malua, who was then the legal advisor of the OAU, who represented African states as an observer, mentioned during the negotiations that, in fact, the continent of Africa had a special interest in the establishment of the ICC because its people had for centuries endured human rights atrocities such as slavery, colonial wars, and other horrific acts of war and violence, which continued up to 1998 and obviously subsequently since then. So in many ways, this idea of an Africa-ICC symbiosis has been there from the beginning. A second point why this is really, really important for us as SILPA to host this event is essentially the focus on Africa has generated pushback. Maybe this is unsurprising. I think Klaus highlighted this, Mark has also highlighted this. And we've seen that early on, as around 2009, African states pushed back at the ICC, taking a decision at the highest level of the Assembly of Heads of State, basically that they will not cooperate with the court, especially in the context of what was happening in Sudan, and later on, Kenya came along. We know they also went up to the Security Council looking for a deferral of both the Sudan and subsequently the Kenyan situations. In the case of Kenya, of course, twice. Of course, none of those were successful. We know that African states generated a lot of pushback at the political level, with African leaders saying that the court is race baiting or chasing Africa. We heard a lot of rhetoric. But on the other side, we also know that the court had some challenges in terms of its legal framework. So we're hoping as SILPA that we'll get into some of the nitty-gritty on some of those substantive points, the questions about accountability and the context of peace processes. So the whole business of sequencing, we're hoping that we'll get into that discussion. And I'll just end on a note of hope that I think we've seen, for those of us who've been observing this relationship for a long time, some shifts over time. And I think this moment seems to be the best we've had for a long time. As difficult as it is to see it that way, we've seen a lot of positive things, including African engagement through the legal processes of the ICC, with African states making the decision to appear before the appeals chamber in an amicus curiae request in the Kenyan situation, and effectively also the ICC now taking that advantage and inviting African states to come before the court to present their arguments in relation to the al-Bashir situation. So this is really, really quite fascinating for me, and I'm hoping that we'll get into that discussion today. I don't want to go on, and let me stop. I just want to welcome all of you, and I will be, of course, open to, we want to have a dialogue with all of you, so the possibility is there for you to put yourself on video if you like, to remain on the audio, and later on to mute and unmute yourself and participate in the conversation. But let me turn it over at this stage to Professor Matiangai Sirleaf, who will be moderating this fantastic discussion that we're hoping to have today. And I'll just start by introducing her very briefly. Professor Matiangai Sirleaf is the Nathan Patz Professor of Law at the University of Maryland School of Law. She writes and teaches in the areas of global public health, public international law, international human rights law, international criminal law, post-conflict and transitional justice and criminal law. She previously served as an associate professor of law at the University of Pittsburgh School of Law in Pennsylvania, and was an assistant professor of law at the University of Baltimore School of Law, and as well as a Chatswood Fellow at the University of Pennsylvania Law School. She's a graduate of Yale Law School, the University of Ghana at Legon, and New York University College of Arts and Sciences. Her scholarship has been published in very respected law reviews in the United States, and she's been also out there in the public spaces on just security, ASIL insights, jurists, and so on. So Matiangai, thank you again for accepting to be the moderator for the conversation. I'm going to turn it over to you, and I'm going to shut up.
Thank you for that kind introduction. I'm really excited to be here with you all today and to help to moderate this conversation. And so Charles already did a lot of good work in sort of setting the ground and setting the stage for today. And I think I would just offer just a couple of additional remarks before introducing our panelists. So I think that Charles highlighted how the allure of universality drew African states to the International Criminal Court. And I think as that allure has faded and the court has not functioned in a way that is truly universal, there has been the initial euphoria that the court was greeted with. There's been some backtracking in terms of the embrace that at least some states have towards the ICC, and that is influenced in part by the selection of cases, and even within the selection of cases, the individuals that are selected for prosecution and the issues that are highlighted for prosecution, and the ways in which indictments have tended to focus on individuals from the global South, namely Black and Brown individuals. And it's important to think about the relationship between international criminal law and the project of international criminal law and its relationship to moves of empire, right? And so some of the charges that the ICC has faced, is it a neo-colonial institution and the like, are influenced by the relationship that the International Criminal Court has with the UN Security Council and the ways in which permanent members of the UN Security Council can effectively immunize themselves from facing the court through either deferral of situations and making sure that they never refer a situation to themselves as a non-state party, in the way that the ICC can intervene in situations with non-state parties through UN Security Council authorization. And so the prospect of the court was greeted with much fanfare. The functioning of the court has taken away some of that allure. And today we are going to be having I think, really interesting conversation about, is there a way forward? How do we chart the course? Is it time to sort of reset the relationship between the ICC and African states? Where does civil society fit into this conversation? I think is also important, because it's not just about sort of what African elites or heads of states think with respect to the International Criminal Court. So we have a new prosecutor, as was alluded to. What does that mean for the relationship? And given that some of the issues that were most on the mind of a number of African states in joining sort of the atrocities suffered during and attendant to colonization and empire building are obviously not within the gaze of international criminal law generally, and certainly the ICC as a specific matter. What is the relevance of the ICC for emancipatory international law, for more globally just international law? And so I'm excited to hear conversations and thoughts around that. And then I also am hoping that we'll have time to sort of engage with the ways in which criminality is shaped as an international project, and what do we think, what does it mean to have sort of who the person that is hostis humanus informed by Blackness, right? And so how does the ICC shape conceptions of guilt, and how does that play on stereotypes of criminality and Black people in the way that white guilt is marginalized because of the ways in which the court functions to not investigate those situations? And what do we make of recent announcements from the new prosecutor that they're planning on scaling back, looking at allegations of atrocities allegedly committed by the US in Afghanistan. So lots of food for thought, lots of things to discuss. And so let me now introduce our esteemed panelists, and we are hoping to have a lot of dialogue. And so I'll be introducing them in the order that they will speak. They will give about 4-minute introductory remarks. I know that we have had some issues with one of our panelists joining, and so we're hoping that he's able to join us soon. I will introduce him in the hopes that he will be able to join us. So first, we'll have Professor Margaret de Guzman, who's James E. Beasley Professor of Law at Temple Law School. She specializes in criminal law, international criminal law, international humanitarian law, international human rights law, and transitional justice. She also teaches a course on mindful lawyering. Her scholarship examines the role of international criminal law in the global legal order, and she has a particular focus on the work of the International Criminal Court. Then we'll have Professor Dapo Akande, who's a professor of public international law at the Blavatnik School of Government. He's a fellow of Exeter College at Oxford, and he's a co-director of the Oxford Institute for Ethics, Law, and Armed Conflict. Before moving to his current position, he was professor of public international law at Oxford Law Faculty, where he was there also the co-director of the Oxford Martin Program on Human Rights for Future Generations. He's held visiting professorships at a number of highly esteemed institutions, including Yale Law School, the University of Miami School of Law, and the Católica Global Law School in Lisbon. He was a 2015 Sir Neenan Stephen Visiting Scholar at the University of Melbourne Law School. And before taking up his position in Oxford, he held positions at the University of Nottingham and the University of Durham. We will then have Professor Charles Jallow speak. He needs no introduction, given that he, I think, ably introduced himself, and we should all be familiar with his work. But I will add just a little bit. So he's a professor of criminal and international law at Florida International University. He's a member of the International Law Commission and has written extensively on the relationship between Africa and the International Criminal Court. His scholarship on this topic includes the lead editor of the book, The International Criminal Court in Africa, which was published by Oxford University Press in 2017. He's also twice appeared as an external amicus curiae counsel representing the AU Commission in proceedings before the appeals chamber of ICC. We hopefully will also be joined by James, who I still don't see yet, but we will be joined by him. I'm speaking it into being. Who's James Nyawo, who's currently a guest researcher at iCourts, the Center for Excellence for International Courts at the University of Copenhagen, where he's researching on the role of the International Criminal Court in the Central African Republic. And he is a lecturer at the School of Security, Diplomacy, and Peace Studies at Kenya University in Nairobi, Kenya. Before joining academia, he served as humanitarian and development practitioner in a number of different countries, and he was awarded a doctorate by the Middlesex University School of Law. So the two questions that are guiding our inquiry for discussion today is, is it time to reset the Africa-ICC or ICC-Africa relationship? And if so, what would that mean and what would that look like? And so I will stop now and let our panelists go. So Meg, I'm turning it over to you for your initial remarks.
Excellent. Thank you so much, Matengai, and thank you to Charles and the other organizers for putting together this really important event and also for including me in it. I want to start by saying that I am not nearly as expert as the other panelists on the legal and political norms in Africa that are going to be discussed as part of this question of the relationship with the ICC. I have certainly spent some time living and working in West Africa and Senegal in particular, and I was a legal advisor to the Senegal delegation in Rome when the ICC Statute was adopted, and I continue to have a focus on Africa. Charles and I are co-authoring a book on the Habre case and have worked together on the proposed African Criminal Court. All that being said, I see my role more as seeking to bring into the discussion some of the big picture framing issues with regard to the role of the ICC and how those framing issues can be part of the effort to reset the relationship between the ICC and African states. So I actually asked to go first so that I could just give some of these general thoughts about what the problems are with how the current ICC, currently the role of the ICC is conceptualized. marginalized and how those impact the relationship. So to sort of quickly answer the two questions posed, I do think there is a need for a reset. And I think that the reset needs to take into account a more clearly developed picture of what the ICC ought to be seeking to accomplish. So I'll start by talking about a couple of narratives about the role of the ICC that I think are problematic, and then suggest one that I think could be more fruitful. And the two problematic narratives that I think dominate the discourse are the what we can call the anti-impunity narrative, that says that the goal of the ICC is to end impunity for the most serious crimes of concern to the international community. This narrative does not define what those most serious crimes are, which is part of what's problematic about it. But more importantly, it's interpreted and used to mean that individual criminal accountability is the solution to problems of mass violence and suffering in the world. And I think that is a very problematic narrative. However, I think there's also increasing recognition among people who think about and advocate for global justice that this narrative is false. And there are a couple of things that I think are starting to be talked about more widely, and Matenge referred to them actually in her opening remarks as well. And the first is that mass suffering is caused by systems, not individuals, right? Systemic racism, economic exploitation, environmental oppression, to name just a few. So holding individuals accountable doesn't begin to address any of these. So if the role of the ICC is really thought of in these narrow terms as holding individuals accountable, and yet with this broad goal of ending impunity for the most serious crimes of concern to the international community, we're missing the primary drivers of these serious crimes, and sort of creating this narrative that we are yet addressing them. So that's problematic. The other thing that I think is emerging and starting to be talked about more is that systems of criminal justice themselves are influenced by racism and other forms of bias, including the influence of political power. And we've seen substantially increased discussions in the United States in recent years about the role of the criminal justice system in perpetuating racism and various forms of discrimination. And we've seen the rise of important movements like the Black Lives Matter movement, the movement to defund the police, and so forth, that are challenging this idea that criminal justice is sort of unbiased and neutral. And I think that these movements are going to make their way into the international court, are making their way slowly into the international criminal justice field as well. And we're starting to see some exciting scholarship, particularly from emerging scholars, about the problematic nature of the systemic bias in international criminal justice itself. So that's the first narrative that I wanted to highlight as problematic. The second narrative that I think is also problematic, specifically with regard to the ICC relationship to the African continent, is the narrative of victim-centered justice. And here I may be a little bit provocative, because many people talk about, and it's by far the most dominant narrative about the work of the ICC, is that it should be focused on providing justice for victims. And I find this narrative to be problematic, largely on realist grounds. I don't think that the ICC is capable of providing any kind of serious, substantial justice for victims of crimes of the kind that the ICC tends to adjudicate. And I think that the narrative that that is the primary goal of the ICC is part of what sets up the problematic relationship with Africa. So when the situations in Africa became the greatest focus of the ICC in the early days, the justification, the primary justification that was given for this by the prosecutor and others, was that the greatest numbers of people are suffering from mass atrocities in Africa. So this kind of argument based on the gravity of the crimes, the gravity of the situations, And therefore, the narrative said, the ICC is here to help the victims. And because the greatest number of victims who need help are in Africa, this justifies these selections of situations in Africa. But if the ICC really can't do much to help victims of atrocities, then we have to find a different role for the ICC if it is to survive. Right? If we think that the ICC is a worthwhile endeavor and it is not really capable, given its limited resources and given, its distance from the victims and we can talk about those details later on. If that's true, there has to be some other role. And the role that I would suggest could make sense for the ICC is one of expressing global norms. And I would suggest that it should more overtly, more fulsomely acknowledge that its real audience is the global community, and that the global community, albeit a very contested concept, is one that is being constructed along with the ICC. If that's the case, then the selection of situations should be about which norms are most in need of expression to the global community, and which will best construct normatively the kind of global community that those of us engaged in this project ought to be trying to construct. And that, of course, is a very complicated, important and complicated question. And I think I'm pretty much out of time, so I won't get more into the details other than to say that I think the first thing that, in terms of selection, that the court should think about is doing no harm. If there is going to be an overt recognition that the primary goal is expressing norms, really expressing norms primarily to the global community. And this is not to say that the ICC can't do anything helpful for the situation companies. It can, but most of that is done behind the scenes. Most of that is done by things like positive complementarity and not by the actual cases and situations that are before the ICC. So the ICC then needs to figure out how to do no harm to those communities and how to more explicitly take into account the needs and goals of the communities most affected by the crimes before it engages in situations and in its selection of cases within situations.
Thank you. We will get more into that, but I want to make sure that we have time to get through everybody's remarks and then have a round or three of questions. Thanks so much for that, Meg. Let's turn it over to Dapo. James, I'm excited to see that you are here with us. So we'll have Dapo speak, and then we'll go to James, and then we'll go to Charles. Thank you.
Thank you very much, Matiangai, and thank you to Charles and the co-sponsors of this event. Thank you for having me. It's great time for us to be discussing this issue of the relationship between Africa and the ICC. And I think it's a great time to be discussing it because of something that Charles said in his opening remarks. He alluded to the fact that things are actually at the moment going sort of reasonably well, and that there has been a change in some senses in that relationship between Africa and the ICC. So what I thought I would do with my opening remarks is really just talk about, it's really just to go over a little bit of the history. How did we get here? And is where we are now a reasonable predictor of where we are likely to go? So let's sort of take it back in one sense to the basics and say, and ask ourselves, what were the reasons for the tensions that we've seen between Africa and the ICC? What are the reasons for Charles's remarks, which I agree with, which is that at the moment, actually, we seem to be in a period of calm. And then where are we likely to go from here? So reminding ourselves of the reasons for the tension, I would say that there were at least two reasons for the tensions, and actually Meg has already noted at least one of these, and others have too. First of all, the fact that at one point, every single situation that was under investigation by the ICC related to an African state, and every single defendant before the ICC was an African. So that was point number one. Point number two, which I actually think was the bigger reason, was actually the fact that when we got to principally 2009, we started to see the indictment of heads of states of African states. people who were either heads of states at the time when they were indicted, Omar al-Bashir, or people who did become heads of state, even though they were not heads of states at that time, the Kenyan president. And I would suggest that actually it was more number 2 than number 1 that caused the tension between Africa and the ICC. It was the fact that African leaders were being indicted by the ICC, which led, at least institutionally, the African Union to take up the issue of whether or not the ICC was biased against Africa. And this was what led us to calls for withdrawals, issues around deferrals, and all the other things that we are familiar with. Now, let's look at the picture today. And just earlier on, I just looked at the map. If you go to the ICC website, there's a map there that shows situations under investigation. You see the states that comprise of those situations colored in blue, most of them still in Africa, but you see a handful outside of Africa. So that map looks a little bit different. And the other thing that is very different, which is what leads us to what Charles was saying earlier on, is that for the first time, we seem to have the impression that the ICC is actually taking on some of the bigger powers. So though that map includes Georgia in Europe, Afghanistan, Bangladesh, the Philippines, there seems to be the potential that, or at least there seemed until recently to be the potential that maybe US actions might be in the view of the ICC, maybe Russian actions, and in Iraq, maybe the UK. So there seemed to be this thing. And number 2 then, going back to the number 2 issue, African leaders are no longer, the potential, at least at the moment, of African leaders standing trial before the ICC today has diminished, with the dropping of the investigations and the prosecutions, in Kenya, and of course with Omar al-Bashir being deposed, even though he may end up on trial, but he won't be the president. So question then, that's where we are today, and that's why I think things look good. Question then, is this a reasonable predictor of where we are likely to go in the future? My own prediction is that the biggest issue, the issue of leaders being indicted, possibly even standing trial, I think that issue is at some point likely to come back. And some of the legal questions, which I'm sure we will get into, which underlay that tension, I suspect are going to come back again. The first issue, though, the issue about investigations and prosecutions outside of the African continent, I suspect that the trend that we see is one that is likely to continue, though, as Matiangai indicated earlier on, we see in Afghanistan, the prosecutor saying they're going to prioritize, the Taliban, they're going to essentially deprioritize US actions. But I think the overall picture of out of Africa investigations is likely to continue. And that's likely to lead at least to addressing that first issue. But I suspect, and this is all I'll say in closing as a preliminary remark to get to some of the issues, that some of those issues and some of those tensions, some of those legal questions relating to the prosecution of leaders, we're probably going to see a resurgence at some point. And in fact, we're almost certainly going to see it if the ICC is to be regarded as a credible institution. If it's not to be an institution that only prosecutes non-state groups, it will have to at some point also prosecute government officials and senior government officials. So we're in a good place, and a good place to reassess for the future when those storms perhaps return.
Thanks, Dapo. We'll go to James for his opening remarks.
Thank you so much, Dr. Matiangai. I hope you can hear me very well. Yeah, my apologies for having some technical issues here and there, but now I'm here. And I'm so honored to be part of this important discussion on the relationship between Africa and the International Criminal Court. I missed the part of the preliminary remarks from others, so maybe I might be repetitive, but I think it's important that we are focusing on this question, is it time to reset the Africa and ICC relationship. Actually, when I was thinking and reflecting about this topic, I thought perhaps an alternative verb which we could have used is that, is it time to reimagine instead of resetting? Because by resetting, it's like we want to go back to the factory settings that were there about 2 decades ago when the International Criminal Court became operational. And if we do so, to go back to the reset factory settings, it will be difficult for us to have a win-win situation between Africa and the ICC, which is the second part of our discussion today. Why do I say so? Yeah, it's because over the past 2 decades, since the ICC became operational, we have learned a lot of lessons, for instance, about Africa's sensitivities and approaches to international system in general. And we have also learned about the ICC's institutional strength and weaknesses. Such knowledge, in my view, is very important to reimagine how the 2 institutions should re-engage going forward. Because it would be rather counterproductive to stick to the assumptions we had 20 years ago in the light of the new evidence on how the Rome Statute justice system could work. I'm sure 20 years ago, we're very optimistic that states were going to cooperate, states were going to surrender and surrender suspects to the International Criminal Court. We were suspicious, there was suspicion on the possible role of the United Nations Security Council. And that became a reality. And adding to what Dapo said, I think for me, that's the third cause of the tension between the African continent and the International Criminal Court, the role of the United Nations Security Council. However, since I've said that we have learned a lot of lessons over the past 2 decades, it's, I think, important for me to elaborate on that. I think the first lesson which we should always be aware of is how history and memory influences Africa's approach and its engagement within the international system. I know it might sound a little bit repetitive that we go back to the historical injustices, but in as far as we are talking about international criminal justice now, we tend to refer to the Nuremberg trials, which is history. We tend to refer to the atrocities committed during the First, Second World War. And the same applies as well to the African consciousness, that there are a lot of historical injustices that still forms part and parcel of Africa's way of thinking, African leaders' way of thinking, and African scholars' way of thinking. So it's very important that whenever we are when we are analyzing and trying to reset the relationship between the two, going forward, we should not forget or take for granted the historical injustice that Africa went through. So that's the first lesson. The second lesson is that the ICC is operating in a very uneven legal and political international framework. And here I want to draw your attention to the role of the United Nations Security Council, which we all know that 3 of the countries of the permanent members of the Security Council did not ratify the Rome Statute. Yet we find them referring some states to the International Criminal Court and between the International Criminal Court and Africa. Because if we are to trace where the tension started, I think it was the indictment of President Omar, former of Sudan, President Omar Bashir. So I think that's one of the realities that we have come to know over the past 2 decades. Then the third one is the sad reality that, contrary to the perception, contrary to the view that by having international institutions, countries were going to surrender some of their authority or their right to prosecute people or those who committed atrocities. The sad reality is that the enforcement of international criminal law primarily remains a voluntary act of sovereign states. And that's why I think in Afghanistan, I think the Office of the Prosecutor realized that it might be difficult for them to continue pursuing what happened there vis-a-vis some of the American operations there. Then finally, I think the other lesson we have learned is that the ICC has limited resources and capacity. And it cannot intervene in all situations. It does not have that capacity to intervene in all situations, because so far, I think like what Margaret said, during the second prosecutor's term, Madam Bensouda, she emphasized a lot on victims. But if we are going to look at how many victims actually received justice, we'll see that it failed in that case. And it's we have to accept that and try to reimagine its role, given the limitations that we know it's facing or it's inherent in internally to it. And this has forced also the International Criminal Court to exercise a little bit of legal realism, to realize that, okay, it cannot be everywhere, but to prioritize. Now the issue is, how is it going to prioritize without hurting its legitimacy? These are my few remarks. Thank you so much, and I look forward to the discussion. Thank you.
Thanks so much to you, James, and the rest of the panelists for exercising discipline. I know that there's so much here to cover. I'll turn it over to Charles, and then we'll open it up for further discussion.
Thank you so much. Thank you so much, Matiangai, and thanks to all the colleagues that have spoken. I think in terms of the question, whether it is time to reset, or as James proposes, reimagine the Africa-ICC relationship, I would say my simple answer is yes. I guess the more difficult question would be the second one, which is, what would that relationship look like? And essentially, going back to a point that Dapo made earlier, I would say that it takes two to tango. And I think James and Dapo and Meg have highlighted some of the big picture challenges about the very role of the ICC itself. So as I think of this relationship in my prior work, I've always tried to separate essentially two elements. And I just want to flag 3 points in each of these, if you will, baskets, so to speak. The first is to think about what are the political dimensions of the relationship. A political dimension that is inevitable when you're talking about relationships between states and international organizations, including ones that they are party to. So essentially, the political challenges in the relationship between Africa and the International Criminal Court. And I'll just say a couple of things about those, and then go to the second basket of issues that I see that tend to be what I would consider legal challenges that would undermine or potentially destroy that relationship. So starting with the first category of political challenges, I think the context is very, very important. And I think this is a point that already has been made very well by you, Matiangai, by Dapo, but I think in a very kind of big picture way just now by James concerning history and the role of memory and where we start from when we think about issues of accountability, especially in international criminal law. That's one element of it. So essentially, there's a long history of Africa's relationship with international law as a field that reflects the positioning of African states over time, historically, as countries that were colonized, that faced the depredations of colonialism, and then eventually, through the process of self-determination, more or less right after World War II, acquired the independence for them to be, if you will, the folks that would determine their own destiny. So really to exercise the right of self-determination. And I think that history of a troubled relationship between the region, which is of course not unique because we saw that also in Asia, we see that in Latin America, obviously different temporal timelines, right? Temporal elements can be included, but there's a really an important piece of how Africa sits within the international legal order. And I think to connect that to the ICC system is very, very important because we can only appreciate the African reactions when we understand that dimension. The second point, I think, is a point about the power distribution, which ties very nicely to this point. And of course, the role of the Security Council is a key part of that. And it's interesting for me historically that when you go back to the records of the Rome negotiations, one of the strident voices at Rome was India. And India expressed a big concern that the ICC would have the involvement of the Security Council, ultimately in what became the referral as well as deferral of situations. And the warning that India gave was that you're going to politicize the institution. And it's really, really remarkable. If you go back to look at the statements of the Indian delegate to the Rome negotiations, it's almost like it was predicting what eventually happened if you look at the Africa-ICC relationship. Essentially, it was seen as a politicization of the institution because obviously the Security Council has a significantly important responsibility for the maintenance of international peace and security in the aftermath of World War II, but ultimately it is, of course, a political body and it makes decisions largely on political grounds. And when that comes into the mix and you think about the referrals of situations to the ICC and the situations that have not been referred to the ICC, you can see the potential for this argument of double standard and selectivity on the part of the Security Council to be a political problem for the ICC. So that's my second point about the role of the Security Council and the double standard argument that we hear from African states. And the final point, which is again in this political basket, is really about the situation of African countries that are conflict-ridden. So you have a set of countries that are struggling with conflicts in some cases for decades. If you think about Sudan, and African leaders were engaging in processes to find solutions to those conflicts. So enter the International Criminal Court by way of a referral from the Security Council, and African states immediately react. Not so much just the point that Dapo was making, which I agree with, which is that once you get an indictment of an African president, that will get attention. There was also this underlying element of, well, how do we sequence justice with peace? How do we think about the interests of justice, perhaps in a broader sense than just indicting a leader and sending them off to The Hague? So that's the third point that I see as a challenge in the relationship. So let me just pivot now to the legal issues that I see. And here, I would say that I would see at least 3 points that in my view undermine the prospects for the relationship. One is a systemic design point, which is that, of course, the ICC has always had this element of jurisdiction over the nationals of non-state parties. And this is something obviously that was of concern to not just African states, but also the United States. And in fact, is one of the reasons why the United States is not a party to the Rome Statute system. So that jurisdiction, the ability of the court to reach individuals where the states themselves have not willingly accepted the court, of course, connects as a legal matter to the element of the Security Council. And obviously, the second interrelated point is the issue of immunity. When then you implicate, when the ICC implicates suspects who happen to be leaders, and the question of Article 27 and the obligations under Article 98(1) of the Rome Statute come into the mix. So the conflict between Article 27 and 98, which essentially is a conflict and a legal debate that we've seen in the court that in many ways continues to remain unresolved. And the final point I'll end on in terms of these legal challenges in the relationship is the way the ICC organs have interpreted the Rome Statute system. And I'm talking about everything from the way the judges have viewed complementarity. And this connects to Meg's point about what is the ICC supposed to be doing? Is it supposed to be giving justice or some kind of symbolic, expressive kind of justice? I think it's a very, very important point. And the ICC, I'm not sure itself understands what its role is supposed to be. Because then, of course, when you start from the point of departure that you're going to be involving yourself in a lot of situations, as opposed to selecting carefully the situations that you get involved in, you're going to get into trouble. So the issue of how the court has interpreted complementarity and what the complementarity standard means, including in situations like Kenya, becomes part of the problem. The second example of this, and I'll end on that example, is the way the OTP, the Office of the Prosecutor, understood what the interests of justice mean in Article 53 of the Rome Statute. And I know we're going to come back to these points later on, but of course, as we all know, famously, the Ocampo line was, I'm just a prosecutor over here. If you're concerned about peace, go talk to the Security Council. It's not my problem. Of course, it's in the statute. If you go to the history and look at how the interest of justice was included, you see that states were having a more nuanced view of when the prosecutor might say, okay, you know what? There's something else going on here. I'm going to hold myself in abeyance and let this process play out. So it was too simple to say, go to New York, go talk to the Security Council, given that even when you go to the Security Council, now you, of course, already have given up a significant power of yourself as an entity within the system. And there's a famous back and forth between African states and Ocampo, where they personally cited him for being rude towards African leaders. I think it speaks to that angst that was not understood very well back then. Now, of course, today we're in a different world, and hopefully, as James pointed out, we have more experience with the system of the ICC itself, so we will see how that plays out under a new prosecutor. I'll leave it at that. Thank you so very much. So essentially, I see the legal challenges and political challenges, and I think we have to address this along with the points that our colleagues have raised to be able to get a better relationship in terms of the second part, what that relationship of respect and mutual interdependence would look like. Thank you very much.
So thanks everybody for those fascinating comments. I think we heard so much from that first round, and one just sort of rethinking or reimagining what the relationship between the ICC and African states could be, just consideration of what the purpose of the ICC is and what goals it can actually achieve, and maybe a streamlining of that, thinking about questions surrounding immunity and controversies surrounding head of state immunity in particular, also questions surrounding the selectivity of cases and discussions surrounding determination of the interest of justice and peace and justice considerations. And so if those were the primary issues sort of driving fissures or tensions in the relationship between African states and the ICC, how do we then think about this opening? That is there a period of opening that's happening? And if there is, what is creating that space for a potential change, whether it's a resetting or reimagining? What are the issues that you see as creating space for rethinking what the relationship between the ICC and Africa could be? So I'm curious to hear if you guys, if we spent a lot of time thinking about sort of historically what has been points of controversy. What do you think in this current moment allows for greater opening? Is that changes at leadership? Is that because there is less of a focus on prosecuting sitting heads of states? I'm curious to hear why you all think that there is a space for opening. Anybody who wants to go? Meg, I see you. Yeah.
I mean, I can start us out. I think that the fact that the ICC is being cited as either a failure or close to being a failure is actually an opening, right? It's both the change in leadership and the fact that the ICC is kind of in crisis mode that provides an opening for a really radical rethinking or reimagining, as James said, of the ICC's role. And so I think that we're at a point in particular, and I want to agree with what others have said about the importance of rethinking the way that complementarity works and the way that selections of situations work. Cases as well, but first situations. And one of the most important things that the first two prosecutors did that I think needs to be rethought is they interpreted the Rome Statute to require them to investigate whenever there's a reasonable basis to do so, basically. They did that in part because, as Charles pointed out, they took a very narrow view of the interests of justice. And we've seen where that's gotten us, right? It's gotten us too many situations with too few resources and too little support. You know, even when the Security Council has referred situations, it hasn't actually given any additional support. So I think the fact that we're in crisis is one thing that helps me to have optimism that there may be room for change.
Dapo, go ahead.
Another thing that I think has created an opening for a rethinking is the fact that we've had a bit of a lull in the crisis. It's not that long ago that African leaders were at meetings in the African Union discussing mass withdrawal from the ICC statute. And that did not happen. We had some attempted withdrawals, you know, South Africa, the Gambia. We had one actual withdrawal, Burundi, but overall, we haven't seen mass withdrawal. So we've just actually sort of come out of a crisis mode. And that also gives an opening for sort of rethinking, where do we go from here? we have the space actually to talk about these issues in a way in which we didn't have the space at the time when the conversation was very, very heated politically. And that's a good thing.
Anybody else want to offer thoughts on that? James.
Yeah, if I may, thank you. In addition to us coming out of this crisis and the ICC having a reality check to come to its senses or to realize that the image that it had 20 years ago, or maybe as projected by Mr. Okambo, was unrealistic. And because they overpromised as an institution and really under-delivered. So I think there is an internal soul-searching process going there, looking at what is happening with the independent expert review of the ICC and so forth, to actually say, okay, I think let's go back to basics. Let's really understand what we can do and what we cannot do and move on. So I think there's that realization. But also on the African side, I think the reality is that I think African states in general, most of them are very vulnerable to instability. I think we have seen that with Arab Spring and what also happened in South Africa recently and what's happening in Cabo Delgado and so forth. And that instability threatens the status quo very rapidly. That one day you are the prime president, very vocal against the International Criminal Court, but the next day you are a prison, right? You're a prison. And then you would start thinking, where do I really get the best chance of an acquittal or proper justice? Is it from the former opposition party or rebel leader, or maybe to the ICC? I'll give you a concrete example. You remember in around 2009, the former was the chair of the African Union Commission, Jean Ping, right? He was really against, he was the vocal, he was the leading voice against the International Criminal Court. Then he went to Gabon and he ran for president, I think, and then things did not go very well. And he was the first person to say, actually, we need to go to the International Criminal Court. So although it's not really declared, there is an interest amongst the African political elite to have the International Criminal Court there as an alternative way for justice for them, especially in the event that they lose power. So that's how I know. So that's an opening. I think that's a space there. What's important, I think, is to identify the critical moments for intervention to make sure that we harness that realization by both institutions to say, okay, where do we start and move forward? Thank you.
Thanks for that, James. Charles, did you want to jump in?
Yes, very briefly. Thank you so much. I agree. I think it's a moment, we're in a lull, as Davo puts it. And perhaps the fact that the leaders of African states that were indicted by the ICC, plus this ICC in crisis point that Meg was making, all of those are part of the mix. And maybe the passage of time, 20 years later, the ICC can see hopefully more clearly some of its own limitations. But I would say that perhaps if you step back a little bit, I would tend to think of it as what's happening in the ICC as a whole that may create the conditions for that opportunity to be taken. But also on the other side of the ledger, what's happening in Africa, including in African states, especially key African states, that could then create the opportunities for a better relationship. So if you start with the ICC side, we already talked about how the court is interpreting complementarity, but let's not forget when it comes to things like immunity as well. Finally, we have a ruling from the appeals chamber of the ICC on the question of immunity. And we have Dapo here, who spent many years writing and thinking about immunity and basically say, why is the court not saying anything? I mean, there was a whole movement by African states to go to the International Court of Justice to look for an advisory opinion because the ICC didn't say anything about it. Ultimately, they did say, well, they said something and they were inconsistent. That didn't help either. So you had the Malawi-Chad decisions, you get the decisions concerning Sudan and then the ones in South Africa. And ultimately, they say something, and even that is contested. But if you will, at least in terms of the states parties to the Rome Statute, we have a little bit more understanding of what the judges think the obligations are, at least in relation to Article 2798 conflict. So that's something there that I think could be an opportunity. Now, I should note, of course, that African states have pushed back at that decision, right? So it's not that the decision has been taken lightly, but because we don't have anyone actively, like any sitting president, indicted by the tribunal, perhaps that is a window for us to have a discussion about that. Then, of course, we have the leadership changes in the OTP, and perhaps a hope that there could be changes in terms of prosecutorial strategy. What I hope that the new prosecutor will think about is, rather than spreading the court too thin, which is something that has been highlighted here, where do we focus on the symbolic prosecutions of those bearing greatest responsibility? How do we become more effective in those situations as opposed to going for low-level, hanging fruit, low-lying individuals and bringing them to the Hague and then failing even in successfully prosecuting those cases? Now, of course, we have the new presidency of the tribunal, we have new judges and so on. All of those could be factors on the ICC side of things. And I think the conditions are better now than they were many years ago in that regard. Very quickly on the African side, I think we've seen changes in African countries that are positive. You think about South Africa, the leadership change there. I can talk a little bit of what's happening with the relationship between the executive branch and parliament. So the withdrawal did not happen. If there are positive changes in the Gambia, it seems as if we're taking a step back in the Gambia. We don't know, with the return of Jammeh acolytes into the new sort of dispensation in the Gambia, what that could mean for international justice. But further on, and very importantly, and I'll end on this note, there's something significant happening in the Sudan. And James has written about this, in a sense, taking advantage of this moment, because African states like Sudan are now finally saying, we're willing to even join the Rome Statute system. And we might even cooperate with the court. And by the way, we might even turn over al-Bashir. I don't know whether it would happen. We've talked about coup d'etats, and we've seen coup d'etats now in the mix and what have you. But the point is, there's some significant development, because if you go back to the beginning, the whole, if you will, the dogs were let out when they had the indictment of al-Bashir. So if al-Bashir is in the Hague, having to get a chance to answer to the charges, maybe with Sudan in the room, maybe that would change the dynamic. I'll stop there. Thank you very much.
Dapo, you were invoked just now, so I don't know if you want to respond or expand on the issue of immunity, but I wanted to offer you the opportunity to now, if you do.
Yeah, sure. I mean, again, a little bit of history and then looking further forward. Charles has actually said it. One of the things that I think was really poisonous in the relationship between Africa and the ICC was not just the fact that a sitting president was indicted. That was, in the views of African leaders, sort of bad enough. And Charles rightly highlighted actually the implications of this for sort of peace and justice issues. But it was actually also the way in which it played out. So you had consistently African states in Addis Ababa issuing resolutions saying, what about immunity? But for a while, you had nothing from the ICC actually talking about this issue. So, you had the arrest warrant decision, said nothing about it. You had a number of cases where African states were, if you like, sort of reported to the Security Council by the ICC, wagging the finger, you didn't arrest. So they're shouting in Addis, what about immunity? ICC saying nothing about immunity in The Hague. Okay, eventually the judges then decided, okay, we'll take on the immunity issue. And then we had the inconsistent decisions that Charles has just talked about. But they chose, that was a good thing. They chose to talk about it, but then we had the inconsistent decisions. And then, of course, finally, we had the decision in the Jordan appeal, the decision of the appeals chamber, talking at length about this issue of whether serving heads of states are immune, not just from the jurisdiction of the ICC, but also immune when they are arrested by, or sought to be arrested by, a state and surrendered by a state that's acting at the request of the ICC. And that decision, some of us, myself included, have been very critical of that decision, but at least they chose to deal with it. I think that issue will come back, because there was a lot of dissatisfaction with African states in relation to that position that was taken. There was, at one point, a sort of building campaign amongst African states to have an advisory opinion by the ICJ. The African Union was thinking about this very seriously. It was actually placed on the agenda of the General Assembly. And the only thing that I think, well, meant that this didn't happen is the fact that Sudanese president, the then president, Omar al-Bashir, fell from power. If that had not happened, I think the issue of an ICJ advisory opinion would have been pushed, and then there would be that question. So this question, I think, will probably come back the next time you have a sitting head of state that is indicted, if at least that head of state is not the head of a state of a party, a Rome Statute party. At least in that circumstance, I think it will probably come back. And so we need to think about what the right answer is. Now, you know, the ICC Appeals Chamber has given its answer, and it probably will not change its mind. I mean, who knows, maybe it might do, but that's the answer that it has given. And so we need to see where this issue sort of goes, where we go from there. But at least now we don't have that issue at the moment. You know, we don't have that issue at the moment. I was actually in support of a request for an advisory opinion. And I think I was in support of it for two reasons. Actually, Charles categorized some of his issues earlier on, the political reasons and the legal reasons. You know, politically, the reason why I was in support of a request for an advisory opinion by the ICJ was politically, number one, I think at that point, African states had really stopped listening to the ICC, and whatever the ICC, you know, came up with, I think was unlikely actually to make a difference. And so changing the forum, changing the venue, I think was likely to create a better impression amongst African states and the likelihood that you might actually get some compliance by African states with whatever the law was. The second reason why I was in favor of it at the time was a legal one, which is that there are a whole set of legal issues actually that arise in relation to the ICC, in relation to immunity in the context of the ICC. We've got the Rome Statute, but it's not just about the Rome Statute. You've got the relationship between the Rome Statute and customary international law. You've got the relationship between that and Security Council resolutions. You've got the relationship between those and other treaties that might be relevant. So in the case of South Africa or in the case of Jordan, there were questions about, you know, what's the status of the relevant AU treaties, the relevant Arab League treaties on immunities, and the ICJ probably would be better placed to take a holistic view. So that was the reason why at the time I was in favor of seeking an ICJ advisory opinion.
Thanks for that. So I am mindful of the time. We're going to open up for questions in at 11:30. I wanted to ask the panelists to offer some thoughts, given that we do have a new prosecutor of the International Criminal Court, and so much of the relationship has been informed by who the prosecutor is and how they interpret their discretion and how narrowly or broadly they read different provisions. So from Ocampo to Bensouda, and now with the latest prosecutor having perhaps not as much support from some African states as others have had in the past. I wanted to take a moment for the panelists to just sort of reflect on what they think the leadership change at the OTP means for reimagining the relationship between the ICC and African states. I can cold call.
Megan, Matianga, can I just come in and just say one very brief thing on that, and then I'll leave it to my fellow panelists. You know, the interesting thing is, of course, we've just gone from a situation where the leadership at the ICC was African. The prosecutor was African. The president of the court was African, to a situation where now that is no longer the case. And I think whatever criticisms one might have of the prosecutor and the president of the court, whatever criticisms you might have, they put a lot of energy actually into this question. And they put a lot of energy into quiet and not so quiet diplomacy with African leaders and African states. And I hope that the new leadership will continue to do that. I hope that they will continue to engage actually personally with African states on these questions, because part of it is actually just sort of, I mean, there's a lot that goes into it, but there's also the function of actually just explaining what the ICC is doing and why the ICC is doing what it is doing.
Thanks for that, Dapo. Anyone else?
So I don't want to be cold called, Matianga. So let me jump in on this point. I think that it's interesting, this observation by Dapo about the leadership changes on the ICC side. And it's interesting, Dapo, you could actually even at one point add the presidency of the ASP. Remember the Senegalese Minister of Justice. So in a sense, at the ICC level, there was a strong signal that we hear Africa is also at the table, and let's have that conversation. And I cannot stress enough that there was a lot of effort by both President Chile Oboyo Suji and Prosecutor Fatou Bensouda to engage quietly with African states, including that famous visit by President Oboyo Suji to Nigeria with President Buhari. Very, very big, this is Nigerian president, right? Talking about international justice and so on, to send a signal of support for the court. And that's significant because, of course, Nigeria was sort of like preliminary investigations country still before the ICC. So that's one part of it. But I think when you come back to the OTP itself, I see at least three possibilities. One is a prosecutor who comes in, who takes the lessons of the past 20 years seriously and perhaps revisits some of his policy papers. I hope that that would include Article 53 and the interest of justice understanding. Secondly, and this is to Meg's point about having a prosecutorial strategy that recognizes the limits of the ICC as a court of law. Maybe beyond expressivism, we're not going to give you much. So we'll choose carefully the cases that we address. And thirdly, to actually engage African states on a diplomatic level as well. Now, I have to say that the initial announcements of the special advisors is already very promising from the prosecutor's office. And there's a lot more advisors from all the different regions now. But I do have a criticism there that there was not a single person appointed to be an advisor on Africa-ICC relationship. And of course, I asked this question on Twitter, and Karim Khan responded that the Africans that had been put on there, so this is Justice Chande Usman, as well as Adam Ajeng, would be without portfolio because they will advise beyond Africa. So this is about the whole mandate. I understand that, and I think that's one way to think of it. But I was thinking about the signaling effect of saying, well, I'm going to have special advisors on Africa-ICC relationships, because it's chosen a lot of new topics. It's put them on the agenda. So just at the diplomatic level of reaching out to African states and saying, look, I want to engage with you, and I'm having eminent Africans that can assist me in that regard. I think that's important. So I'm hopeful for policy changes. I'm hopeful for signaling changes, but definitely cannot underscore enough, in my view, the importance of that engagement at the soft level, not in the public, because we've seen that that doesn't work very well. The back and forth between Ocampo and the African leadership is not helpful. So just do it quietly and see where you can make the progress. Thank you.
Meg.
I just want to add one thing, and I hesitated to say anything because I'm still thinking about what I think about this. But when Charles talked about, the public versus quiet role of the prosecutor, it brought to mind this surprising announcement about focusing, deprioritizing the Americans in the Afghanistan investigation. And I'm of a couple of minds about this. I mean, as many people have pointed out, it's very disappointing. And particularly if one thinks of the role of the ICC as being about expressing norms, and one believes that one of the most important norms that can be expressed is that powerful countries are within the ambit of global justice, this development is disappointing. But in terms of what it signals about how Karim Khan approaches the job, one thing that occurs to me is that maybe he's going to be more explicit in his acknowledgement of the role that politics play in limiting his options, in limiting his power. And that might be a good thing. And this is why I say I'm really hesitant to talk about it, because I'm not sure. I mean, on the one hand, I think, well, did he really have to say that? Because saying it, doesn't make the ICC look very good. On the other hand, I think, well, if it's true that he is not going to be able logistically to get anywhere with the investigation of Americans because the US is not going to cooperate, is there something to be said for openly acknowledging that? Like, as James pointed out in his opening comments, the ICC is operating in a very uneven political environment, and the power distributions have plagued the justice endeavor from the beginning. And maybe more open acknowledgement of that and of the effects of that on the ICC will kind of lift the veil of, you know, the ICC's ability to be sort of this neutral arbiter of global justice.
So I wanted to allow anybody who wants to, James, I looked like you wanted to react to that. So I'm going to let you react, and then I will encourage folks to continue adding to the queue of questions, which I see being populated. Go ahead, James.
It's going to be very brief. Thank you. It's actually to say I'm very optimistic with the new prosecutor. I think his approach seems to reflect a deep understanding that apart from being a legal court, the ICC is also an organization with limitations. I think the fact that he managed to go to Sudan on several occasions, having been also in the defense teams for several individuals who were indicted, I think he does have, he comes across to me as someone who understands that the previous prosecutors might not have had an opportunity to do thorough investigations, to have enough evidence such that it's important not to be so dramatic about Bashir coming to The Hague because you want him in The Hague, because in the event that you take him to The Hague and he's going to be acquitted because you do not have enough evidence, it will be really a big blow for the International Criminal Court. So it seems, you know, his free charter diplomacy with Sudanese authorities reflects I think, that caution that I think he needs to do things properly. Let me put it that way. He understands the limitations of the previous approaches, strategies that were used, and the limitations that the International Criminal Court might have. So I think that's all I wanted to say. That so far, I think I'm very optimistic. On the issue of the appointment of these special advisors, I would have really wished for him to appoint a former head of state to be based in Addis Ababa. That would have really helped him to unlock a lot. I think in the African context, it seems head of state talking to another head of state, you gain more in terms of negotiations. Thank you.
Thanks for that. So we're going to transition now to Q&A, and there are a couple of questions. Javier, you're welcome to unmute yourself and ask the question if you're available now. I'm also happy to read the question if you don't want to reveal yourself via video and voice. Okay, you're happy to listen to my voice. All right, so Javier's question is, could the reimagining of the relationship include a move towards regionalization via the Malabo Protocol? Has not seen any ratification so far, and this is an interesting question because I think it's tied to sort of at the height of tensions, it seemed like there might not only be a withdrawal, but also the possibility of the creation of an institution that would be regional, that would prosecute a number of things beyond the scope of the International Criminal Court. And I read his question to say, can we think about reimagining the relationship to include sort of looking beyond the ICC towards a regional effort that's through the Malabo Protocol. Thoughts on that?
Yeah, so if I may, it's a great question. I think the Malabo Protocol definitely fits into the scheme of this tension, and then a look back by African states for the so-called, African solutions to African problems. And of course, they've adopted a very ambitious document with about 14 crimes, what I call ICC plus crimes. So you have the traditional, war crimes, crimes against humanity, genocide, and the crime of aggression, but you also have 10 other crimes, including environmental crimes, what I call public order crimes, if you think about unconstitutional change of government and so on. So it's a very, very ambitious instrument. At this stage, we've had a number of signatories, but Javier, you are right that there has been 0 ratifications. And all they would need ultimately is about 15 in total for the instrument to come into force. Those who've studied African treaty-making practice, I'm thinking here of Professor Tia Malua, have suggested that at the minimum, it takes around roughly 7 years for an African instrument to get the 15 ratifications, an AU regional instrument, sometimes much longer. And I would like to venture that the Malabo Protocol may be in either of these categories of you get a quick set of ratifications back on the back of the signatures that we've received so far, perhaps because there's a catalyzing factor, right? Something happens in the Africa-ICC relationship and you go back, digging for the African solutions, and then you ratify very quickly. But there's also the possibility that because nothing happens between African states at the leadership level and the ICC, that this slowly grinds on, and it will take many, many years. But it does mean that ultimately, at least in my view, you would have an institution at the regional level. And of course, that then raises the question of the complementarity framework of that regional body vis-a-vis African states parties, but also vis-a-vis the International Criminal Court. How do you have that division of labor? And I think, in fact, Meg here has done a study, was part of this large project that we did on the Malabo Protocol, where she looked at the interpretation of complementarity. And I would connect it to Kenya's proposal at the ICC Working Group on Amendments to actually explicitly provide for regional mechanism. That hasn't gone anywhere. But it's just to say that I can imagine a world where you have the regional court as part of the solution for accountability on the continent, but it's probably a long ways away. And obviously there will be the questions of resources as well that have plagued quite a few African institutions. That will be a challenge for the Malabo court as well.
If it's okay, I'd like to jump in here on that question and on the one that was directed to me. Unfortunately, as the others on the panel know, I have to jump off after these comments for another obligation that predated my being invited to this excellent panel. I guess what I'd like to say, both in response to the question about the Malabo Protocol and the question of, is it problematic to think about this expressive mission in terms of the individuals being instrumentalized? I think the answer to the second question is no, and I think it's actually related to the role of the protocol. I think we ought to think of the ICC as part of what will hopefully eventually be a robust menu of options for addressing the kinds of crimes that come before the ICC now. And the Malabo Protocol and the potential for regional justice in Africa and potentially in other parts of the world. There's an effort, the COPLA in Latin America and the Caribbean, to create some kind of regional justice as well. I see those as complementing eventually the ICC, just as national courts ideally should complement the ICC. And so the fact that certain individuals are brought before the ICC and that their cases are used to express norms of global justice isn't unfair, to the extent that that is one piece of the puzzle, and that there are other mechanisms that are available and active in bringing other perpetrators to justice. So I just want to also, since this is the last time I'll have the chance to speak to the group, I just want to end on a note of optimism. And I said earlier that, I think the ICC is in some ways in crisis and sometimes being perceived as having failed or being close to failure. I don't actually share that perception. I think the ICC has, in a short time, done a lot of very impressive work to get the enterprise of global justice off the ground, and probably more than many of us who were in Rome anticipated it being able to do in the political environment in which it has to operate. And so I am optimistic. And as James said, I think that this prosecutor, presents some really exciting opportunities for reimagining the ICC Africa relationship. So on that note of optimism, I'm afraid I have to leave you, and I'll have to watch the rest of the panel recorded. Thank you so much again for including me.
Meg, thank you so much for joining us, and thank you for your comments. And we'll be sure to share the questions for you for follow-up in the chat. Thanks again. So there are a bunch of more questions coming in, and so I want to make sure that we have time for them. And so Beth, I was going to go to you, and you are welcome to sort of read your question if you would like.
No, I'm happy for you to read it. So that's fine.
Okay, this is, I'm sorry, Charles, I don't know what to say. I know you wanted people to to ask the questions, but you know, here we are, here I am. Okay, so Beth's question to everybody is, you know, what impact, if any, does the lack of fairness in the proceedings, specifically surrounding the inequality of resources provided for the prosecution and defense, have on the ability to sort of reimagine the relationship between the ICC and African states? She specifically is a defense counsel in an ICC case, and so made a note of that.
So maybe I can try, since I've worked in the defense before in the tribunals and have definitely a lot of sympathy for where Beth is coming from. Beth, I had the honor of working in the defense in the Special Court for Sierra Leone, which was famously under-resourced compared to other defense officers in all of the international tribunals that are out there. And I'm wondering, if in the context of the ICC, I guess it's perhaps a little bit of a different context, in the sense that you have a court that's sitting in The Hague and primarily defendants coming from faraway places, but at the same time limitations on the budget of the institution as a whole. And I'm saying that having in mind that when Madam Bensouda was asked the question, what was our biggest challenge in our final year as a prosecutor, she said lack of resources. So she was asked to do more with less. More situations were referred to the court, and she's always told that there's a zero growth budget, so do more with less. And she talked about how she basically they have to triage the investigators from situation to situation. I mean, it's really, really challenging for the prosecution. And I'm making that point to say that perhaps from the point of view of the defense, maybe even more challenging, because I know that at least in the experiences of the tribunals that I had, being in where the easiest place to cut is the defense, right? This is the least popular organ, if you will, of the entire process. So I could see some challenges there, but at the same time, if you think about the kinds of cases we've had at the ICC, some of these individuals have been accused, they do have the means to hire good defense counsel. So perhaps there's a little bit of, I could see it playing into concerns about how fair the ICC is, but I could also see it in a bit more of a positive light vis-a-vis the challenges of the institution as a whole, that yes, maybe it's better to have more defense resources, but at the same time that maybe all in all, it may be a bit of a better funded defense than you might get elsewhere. I don't know that that satisfies you probably as a defense counsel, but I'll just end on that note.
Go ahead, Dapo.
Thank you. I just wanted to make one point here, and I'm really going out on a limb in the sense that I've not worked directly as counsel in the way that Beth and Charles have. But one point that I wanted to make is that at one level, one might say that these two things are unconnected. So the fairness of the proceedings and the specific issue of the relationship between the ICC and Africa. But at another level, I think it plays into the bigger narrative. And I think it's this point that Meg was making, both in opening and in closing, the idea of the ICC as a failing institution, right? The idea of the ICC as an underperforming institution. It just puts more pressure on the court, and it gives more opportunity to sort of, to label more criticisms at the court. And this is what led us to the independent expert review. What led us to the independent expert review was a sort of overall narrative, a global narrative. By global, I don't mean geographically, I just mean in terms of the set of issues, that there's just a whole bunch of issues that are going wrong here in regard to this institution. We're not getting convictions. Some people thought this is a problem, the Africa-ICC issue. So you lump in this issue also of possible lack of fairness to defendants. It adds to this narrative, which then means that the court comes under even more pressure. And I think that's the relationship that I see between these two issues.
Thank you. So we have a question from Sarah. Sarah, I'm going to put you on the spot to ask whether you want to ask your question.
Okay, I can read it.
Yay, thank you.
Yes, my question was like with regards to what has been previously asked. Do you maybe see the ICC in the future prosecuting crimes maybe other than atrocity crimes, maybe violations other than physical integrity, the right to life? And if you would see this as a welcome development and something that should be done. Thank you.
Thanks for that, Sarah.
So I don't know, James, whether you want to react to this. You're on mute, James.
Yeah, I honestly, I don't think so. I think there is already a lot in the ICC jurisdiction and is struggling actually to make headway in prosecuting what is in front of it. I do not see state parties coming and trying to expand its current jurisdiction to include other cases. So I do not think that is I don't see that happening, and I do not think it would be really it would be really important at this stage to think of expanding the jurisdiction of the court at the moment. I think let's support it to achieve what is intended to do, and then thereafter we can see. But yeah, I think that's my brief remarks towards that. Thank you.
I wanted to just add to Sarah's question, because there are things within, thanks for that, James. I think there are things within the ambit of the court that are more systemic, for example, the crime of apartheid. And so, I'm thinking of the situation to the extent that there is a situation that will be investigated with respect to Palestine and Israel, and that determination, which has been ongoing for a while, but there are sort of more systemic violations within the statute that the ICC could be looking at. The crime of apartheid is one of them. And so I want to sort of repose that then back to you all to see whether you think that there is space for, within the world of the statute of the ICC, for thinking about more systemic and structural, I should say, rather, more structural types of crimes. Thank you.
Yeah. So, sorry, go ahead. Go ahead, James.
No, I heard you referring to the crime of apartheid as being, is it part of the? My understanding is that yes, I think it falls under the as a criminal act under crimes against humanity. So I think what is required is for such crimes that are listed under the acts under crimes against humanity to meet the threshold that is required, that is systematic and widespread. I understand that there's a lot of work going on into having a separate treaty for crimes against humanity, and I'm sure Charles and Dapo are much more knowledgeable about that than me. So I would say it seems at the moment the jurisdiction of the court seems to cover quite a vast amount of criminal acts. What's important, I think, is for them to meet the threshold that is required for the International Criminal Court to intervene. But I leave that to the other members here.
So maybe just a couple of quick points, Matianga. So one is to agree with you that what is it, Andre Nolkamper and Herman van der Velde called system criminality. I think there is scope for that to be addressed, and I agree with you. Maybe it's a matter for prosecutorial priority. So when you think about the systemic crimes within the Rome Statute, like the crime of apartheid, maybe there's a possibility there. But if you zoom out, just to maybe add the point that there are states that have been calling for amendments to the Rome Statute from the get-go. If you think about Trinidad and Tobago, they haven't given up on drug trafficking. So the possibility of transnational crimes being included, and there's even talk about terrorism and of course proposals, and this is something I have to confess I've been part of that discussion, to include environmental crimes like the crime of ecocide in the Rome Statute. Now, whether that is as a policy matter, something that would happen now or should happen now is a different conversation and probably something for states. But I could imagine a more robust ICC, a more successful ICC, perhaps down the line, many years down the line, being involved in other crimes as well.
Can I just come in on this and just address one systemic issue? So maybe not the systemic crimes that Matiangai is inviting us to talk about, but one systemic issue that arises whenever new crimes are added to the jurisdiction of the ICC. So to go back to Sarah's original question of, can we foresee new crimes or crimes of a different type being added? So we need to think about how this actually happens, right? So, you have to have an amendment to the statute, and then that amendment comes into force for those states that have accepted the amendment one by one, unless it's done, it's Article 121 that deals with amendments. And typically it's going to be Article 121.5, so one by one. Now, why do I mention this? I mention this because the effect of this is to lead to something that some people have called the fragmentation of the Rome Statute. In other words, you have certain crimes that are applicable with respect to nationals or territories of particular states, because those states have ratified the statute. But then those same crimes do not apply with respect to nationals or territories of other states, because those other states have not ratified the statute. So if you look at, and we have seen amendments to the Rome Statute to add new crimes to the statute. We saw it in Kampala, and we've seen it at a couple of ASBs since Kampala, but I think the very last one being the ASB in 2019, adding the crime of starvation in non-international armed conflicts. Just the other day, actually, I just thought, let me just check, actually, how are these amendments doing? How are they coming along? Crime of aggression, the amendments with respect to the use of certain weaponry. And the sad reality is that they're not coming along well. States are not ratifying these amendments. And so even though we are adding these amendments, and I'm not complaining about adding these amendments. I was strongly in support, actually, of adding both the crime of aggression and the crime of starvation. But unfortunately, states are not ratifying them. And the systemic effect of that is that though they are in force actually only in a very limited number of situations. And that's something that we'll have to think about as well if we are talking about adding new crimes to the jurisdiction of the court.
Thanks for that. So we have some more questions in the chat. Ahlam, are you? Okay, I'll read the question for you per your request. So Ahlam's question is, I believe that it's important to make sure that the relationship between Africa and the ICC is strengthened. Where do you think the burden of the enhancement of the relationship should be, especially with all of the challenges that we've been discussing during this session? Is that upon African states? Is the responsibility on the ICC? Is it some shared responsibility? What are your thoughts?
If I may start. Yeah, okay. I think it's a shared responsibility. I think it's both institutions, the ICC and the African Union, in particular, African states, really need each other in terms of strengthening their legitimacy. So there are aspects that the International Criminal Court will have to address, and in my view, is primarily to listen and to be sensitive to African states' concerns and try to have dialogue and with them. On the issue of African states, I think my take is African states needs to do more for them to be taken seriously as well. Because we cannot have a situation where they come up with amendments, like what I think Charles said, and then they make a lot of initial drama about them. Then along the way, they just drop them like that. I'm talking here about the complementarity proposal amendment, and also the one for the General Assembly to be involved in the deferral or referral of situations. So I think it's both ways. And what's more important is to underscore that the Rome Statute, the ICC remains the court of last resort. And I think it's important for African countries also, where it's possible, for them to take the leadership in prosecuting those who are involved in atrocity crimes, so that we do not have the intervention of the International Criminal Court at the, yeah, I think that's all I can say for now.
Charles?
So I largely, I mean, I entirely agree with James. I think it's a shared responsibility. I see it as a responsibility on the part of the ICC to see what it could do better. And when I say the ICC, I'm aware and mindful that's a complex institution. So I'm thinking about the different organs of the court. Of course, the prosecutor has been a focus of ours because we know that a lot of what the prosecutor does is the first thing that generates reaction from states everywhere in the world. But it's not just the office of the prosecutor, it's also the Assembly of States Parties. The Assembly of States Parties in 2013 convened a special segment on African Union concerns. But then there are no substantive decisions taken. There's work to be done in the context of the working group on amendments. And James is right, that's partly the fault of African states. You don't make proposals in one moment where it seems convenient, and then you walk away from the proposal when it's politically no longer convenient. So I think the mechanisms ought to be used by African states. I also appreciate that African states are now taking the decision to intervene as amici. So in fact, in the Kenyan situation, where I had the honor of appearing on behalf of the AU Commission, it was the first time, and it took a lot of convincing for African states to apply to appear under Rule 103 of the Rules of Procedure and Evidence to make submissions before the ICC Appeals Chamber. And what was really interesting for me is many years later in the al-Bashir hearing, perhaps because of the president being African, they invited the African Union, but not just because of the president being African, because they also invited the EU, the Organization of American States, the United Nations, and the only organization that responded and actually appeared before the court was the African Union. So I think that if you think of it in terms of positive steps, that engagement at a legal level is a very significant development. So I would say on the ICC side, all the institutions ought to look at what they could do better in terms of strengthening the relationship, because ultimately we know there's a win-win that I like to stress for both sides. Now, of course, on the African side, things like following through with your proposals, not threatening to do mass walkouts, and perhaps, especially this office issue of a liaison office in Addis. Come on, having somebody in Addis that you can talk to. You have somebody in New York that is a liaison between the ICC and the UN. You can have somebody in Addis for that. Maybe now when the tensions are not so high, it's a good time to do that as a show of good faith to kind of recalibrate the relationship. But ultimately, I'll just end on the note that perhaps it's not just about the two institutions, it's also about global civil society. And I'm very grateful that now we have a bit more critical look towards the ICC. It used to be that if you criticize the ICC, all these NGOs will go after you and nobody would say anything that was negative about the ICC. But because we've had the opening of the review process, there's an openness there, but also on the African civil society side to hold African governments to account, but also to be able to put forward their own submissions. So I'll end on that. I know Dapo may have even better ideas on all of this.
Just to say no better ideas, I agree entirely with what James and Charles have just been saying. So nothing to add on that front.
If I may, just one point, sorry, just to give you an example where I felt African state parties missed an opportunity to air their views, is their participation in the independent expert review of the International Criminal Court. You know, it's really, it was really curious that it's only one state actually that made the provisions. So that was a missed opportunity for them to push for the reform or to push forward their agenda. Thank you.
I want to take moderator's privilege, seeing no other questions in the chat. And I think it's important that in these discussions that we sort of explicitly engage with the role of race and the role of racism in international criminal law. And so to the extent that the ICC has been focused on presumably rescuing and protecting Black and Brown peoples through its the focus of its situations and through the focus of its indictments, I think it's important that we discuss the role that race plays in international criminal law within the functioning of the International Criminal Court. And so I wanted to create space for us to talk about that. And so would be hopeful that some of you might offer some remarks on to that end.
Maybe I can come in there and at least express some thoughts on this question. So one of the ways in which the debate was framed when this tension first arose, 2008, 2009, 2010, that period, so a decade ago, and continuing was, whether or not the ICC was biased against Africa and against Africans. And in fact, we had some African leaders expressly saying that the institution was racist. But I think we have to set all of that in context. We have to set all of that in context. And I know that these facts have been said before, but I don't think they lose validity just because they've been said before. We need to remember that the reason why the first few situations that were before the ICC was because African states chose to refer those situations to the ICC. Right. So it's true, of course, that we had an issue with the UN Security Council in the fact that the only cases the Security Council has referred to the ICC are cases arising out of Africa, so Sudan and Libya. But it's not the Security Council that has placed most of the situations on, if you like, the docket of the ICC. It's African states themselves that have placed most of those situations before the ICC, at least in the initial phases. And so that's important for us to remember. And that's why I'm sort of critical of the turn in the narrative essentially comes when you start to see African leaders being indicted. Now, I take the point that we made about peace and justice, and actually I'm also very critical of the court in terms of the narrow interpretation of interests of justice that it took. I think, and also the way in which the point Charles made very eloquently, not for me, you go to New York. So I'm very critical of that. But at the same time, I'm also critical of the fact that we saw a change in narrative by African leaders at the point when it was African leaders being indicted. That was when that change of narrative came. So I think it's important to bear that in mind. It's not just the institution that played at the ICC. It's not just the ICC that actually initiated these processes. African states were also at the center, at least at some stage. Even throughout, actually, this discussion, we continue to see more situations being referred to the ICC by African states themselves.
If I may, sorry.
No, James and then Charles.
Thank you. Yeah, the issue of the International Criminal Court being viewed as racist, I think I agree with what Dapo said, that it's only became an issue after the indictment of President Omar Bashir. But I would like to maybe explain it further and say what's at the root of those claims seems to be the fact that the United Nations Security Council did not bother to respond to the AU's request for deferrals. Because I think in all the communications or the decisions by the African Union, they were not against that we needed accountability for what had happened in Darfur. They were initially, they were really, they said, okay, yes, we understand that there are atrocities and we have indicted some of the individuals, but give us a chance to engage with Sudan on the issue of Darfur through other means. Give us a 1-year deferral, which is provided for in the Rome Statute. But until now, I don't think they received an official communication to that. Of course, there's a lot of debate about that, like what were the African countries willing to give, African Union to give for that deferral to be given. So, but the fact that they were marginalized, they were not taken seriously, it goes back to my first point that African states tend to go to history and memory to say, I think from colonization and so forth, they've always been marginalized when it comes to the issues that pertains to their own situations. So I think that's where the issue of racism came in, because you might remember that the African, around 2007, President Omar Bashir was supposed to be the chairperson of the African Union. But because of what was happening in Darfur, the African Union actually took a stand and said, no, we are not going to allow you to do that. So they wanted the ownership of the process. The fact that the United Nations Security Council took over and did not want to listen to their proposals, I think created this notion that I think the ghost of racism came into place. And lastly, if we go back again into history, going back to colonization, I think the justification was that there were good intentions, right? So again, when the African states, the ruling elites, seem to be losing the control of what's happening or what is being prescribed into their states, they go back and say, no, I think we've walked this path before. Let's be the owners of our own destiny. And that's why with state referrals, we did not hear a lot of noise about that, but it's only how they felt they lost the control of issues when the Security Council intervened. I just wanted to add that dimension as well. Thank you.
Thanks, James. Charles, did you want to add anything, or? You're on mute, I think.
Can you hear me now?
Yes.
Oh, sorry about that. Just very quickly, I was just saying that I think Dapo and James have made some important points. I think if you think of where they slightly might diverge is essentially the framing, the temporal framing of the issue. So if you think about the element of race, which actually was explicitly invoked, I think there's this idea of race haunting Africa. It was made by, I think, the president of Benin. I think President Museveni used this language. I think it's maybe only understood in the historical context. So I take Dapo's point about the self-referrals, which essentially is a kind of like more recent set of events, but I see also the tapping into the long history of relationships between the West and basically the global North by African states that make them very sensitive. Ultimately, I mean, even in the more recent history, we've seen also instances where African states were calling for help. If you think about the Rwandan genocide, I mean, that was the biggest criticism of the African states was we had a moment where we needed the international community's assistance, and the international community failed Africa just because we're Africans. So in a sense, it's ironic that a few years later, African states are now saying the opposite when the court has come into being, a new court, and is focusing on Africa. But I think you will not understand that pushback without going back to where James was coming from. So I'll just end on that note to say that I think if you put it in long historical perspective, you can understand the criticism about race and so on. And I think it's an important point for the ICC to be able to go out there and show more diversity in its work, but also to take into account the power dynamics, the role of the Security Council. This has structural systemic points. And by the way, there's a famous long discussion about Security Council reform. We even have this movement about making sure that you don't use the referral in the, your Chapter 7 powers and veto in the context of atrocity situations. So maybe all of these things ought to be part of the mix. Obviously, they're way beyond Africa alone, but they are part of the conversation. And I think I can understand the impetus to get the criticism from both sides.
So thank you for that. I was going to just add and invoke Kamari a little bit here in her absence, Kamari Clark, just because I think beyond sort of the cynical use of and instrumental use of sort of charges of race, I think there's a more systemic point that Kamari really expertly drew out in this piece on the project of international criminal law and its relationship to white supremacy. And so in that piece, in Just Security, she talks about how the act of naming and ordering without naming or prioritizing other global acts fits into how we understand violence and how we understand structural inequalities, and shapes our perceptions around ideas about criminality, ideas about which are informed by race. And so it's important to think about how she argues the sort of failed state fallacy plays into age-old conceptions of ungovernability, uncivilized peoples, which erases the role of Western countries and their historical culpability in post-colonial state dysfunction. So beyond thinking about sort of how race can be instrumentalized, thinking about sort of more systemically what role looking at race in the space tells us. I am looking at the time and am mindful of it. So I would like to turn now to the panelists to provide some concluding remarks, and we'll go in reverse order. So we'll do James, and then Dapo, and then we'll end with Charles. And you can take it away, James.
Thank you very much. I think I go back to where I started, that we have learned a lot of lessons over the past 20 years, and there is an opportunity for both institutions, Africa and the International Criminal Court, to reimagine their relationship. In terms of concrete actions that could be taken, one of them, I wrote it in one of my my blog posts, that I think we should rethink the idea of shipping Africans to Europe, because it falls into the issue of the history, the historical context that we've been talking about. I think there is an opening here for the International Criminal Court to also invest in having some of the prosecutions here in Africa. And I was giving an example of the former President Omar Bashir. I think it's a low-hanging fruit that could open up a lot, both at political level, but also as an outreach and communication strategy for the International Criminal Court. And I hope that could be taken seriously. That's on the part of the ICC. The Security Council, I think, needs also to contribute and not do harm to the International Criminal Court. First, by not referring situations when they are not ready to see them through. That I think is doing more harm to the International Criminal Court's legitimacy. Back to Africa, I think, I always say, I think for Africa to be taken seriously, I think they need to take themselves seriously as well, especially by seeing through some of their proposal and by thinking them through before putting them on the table. And I think they've an opportunity to do that by engaging, I think, a lot of its own resources. And the Malabo Protocol is I think people are measuring the seriousness of Africa based on the ratification of the Malabo Protocol. And the fact that there are no ratifications, it really raises serious questions about, was the opposition to the International Criminal Court a matter of principle or something else? So I think they need to, that's all I can say, but overall, I think there's an opportunity for both institutions. I think we should not tire in terms of dialogue. I think dialogue is the engagement at different level. Thank you.
Can I just pick up on I think the penultimate point that James was making, which was about the Malabo Protocol, and maybe just broaden that a bit, because I think in terms of the reshaping and the resetting of the relationship between Africa and the ICC, I think it's likely to come in the context of a broader reshaping of the engagement of Africa with international criminal justice. You know, Charles has written about all of it: Africa-ICC, Africa Malabo Protocol, Africa Universal Jurisdiction. And I think all of that is actually necessary because, going back to Meg's point at the beginning, the ICC can only do so much. And I think we're beginning to see the limitations of the ICC. So it's really about thinking about what are the different layers of appropriate engagement of international criminal justice, broadly put, with Africa. Then I also think, and I think Meg also made this point, I also think that both as scholars, as those engaged in the whole international criminal justice movement, we need to really have a rethink about the purposes of international criminal justice. And this is where the whole peace and justice debate issue comes in. You know, the mantra that, you know, there can be no peace without justice, we all say it, you know, many believe it, but actually investigating that relationship is one which I don't think actually we do in a very serious way? What is the room for us to actually think about that relationship? And I think this is something that African states have, in their engagement with international criminal justice, been talking about, broadly speaking. You know, where exactly are the layers where we say, you know, there's room actually for thinking about how peace, what the mechanisms are for bringing peace, and how those mechanisms for bringing peace are going to interact with the mechanisms for justice. I think that saying there's no peace without justice, I think it's been, you know, I think it's actually been, in some respects, part of the underlying problem here, where we just think it's about justice and we don't investigate very closely what the relationship is. It's what has led to this very narrow interpretation of interests of justice at the ICC. And I think we need to think more about this issue in the context of that relationship between Africa and international criminal justice more broadly.
Thanks, Dapo. Charles?
Thank you so much to every one of you for what has really been a truly fascinating and important conversation. I'll just offer some very quick thoughts, being mindful of the time. It's clear to me that the ICC is a significant achievement of the international legal order. The court has a tremendously difficult challenge in front of it, especially in this particular moment. But I do think that the ICC, if it holds true to what it's supposed to be about in the Rome Statute, fair and independent trials that will boost confidence in the ICC as a new institution, I'm not at all going to doubt that it would generate more support for the court and more referrals of situations and even ratifications from African countries. But in other words, the ICC has to prove itself first. So hold true to what you are about in terms of what the Rome Statute mandates you to do. And that might mean, and this is the second point, that you scale down what the ICC expectations put out there in terms of what the ICC itself puts out there. This is Meg's point about what is the ICC about? Is it about expressive justice or is it about something else? In my view, that it cannot realistically do a lot in all the situations around the world. So at best, at minimum, it would, at best, if you will, not minimum, at most, it would get us just a few prosecutions in a handful of situations that really are very symbolic. So I think that bit is very, very important, and maybe focusing on those bearing greatest responsibility is a key part of it, and not spreading yourself too thin. Thirdly, I think that for ICC, it will benefit the ICC, African states can prosecute their own at home. So I think this is where the positive complementarity becomes very important. I understand the impetus. The ICC is not a development agency and so on, all these lines. But I do think that engaging deeply with African states in terms of developing the frameworks that they need at home could be a key part of the solution. So that's the third point. And then finally, just to note that the ICC would not, without substantive engagement with African states, be able to get past the moment that it is in. And I think right now we have an opening, as colleagues have stressed, and that opening is the leadership changes at the court and changes that are happening on the continent and the global dynamic. On the African side, if so I could flip the script and push it back at the African region, I think they should take more responsibility. African states got to do it at home. They got to think about the Malabo Protocol. They got to think about the AU peace and security architecture. Substantial progress has been made in terms of the AU transitional justice policy. Maybe it's time to bring that up to the ICC. Maybe it's time to, if you will, notch up this discussion about peace and justice and engage with the ICC as an institution, including the review and reform process. By the way, we're going to have an event on that specifically to highlight that there was an opportunity there for African states to engage, even though they did not engage yet. Hopefully there's still some time. Secondly, I think for African governments, this business of taking the responsibility seriously at home is a key part of it. You got to respond. You got to show the proof to the communities that you're talking to that you will be responsible for the accountability and move it forward. And third, and kind of the very, very important point about the Malabo Protocol. If you create an institution, you're going to have to support it. So look at that very carefully. And if you will, take through the commitments that you're making and starting with the ratifications and then dealing with the complexity of putting the resources so that if it's not done at the national level, it will be done at the regional level. Although I'm still of the view that it's better at the national level because ultimately the regional and the international are even more complicated. It will be also for African states. And finally, just to note, that as if you will, a player in the international system, nobody's going to invite Africa to the table. Africa has to invite itself. It has opportunities. So when it makes proposals, it's got to follow through with those proposals. I'm not going to say anything other than what James has said. You know, if you put a proposal on complementarity, see it through. Don't make a noise about it one day and then leave the next day and done because the issue has gone away, because it's a systemic point that will be addressed. And I think in the sense of international law more broadly, there are opportunities to clarify African views and African state concerns in terms of immunity, whether in the context of the International Law Commission, whether in the context of the General Assembly, whether in the context of an ICJ advisory opinion. So there are tools out there that African states can use, but ultimately it's just end on a note of positivism, which is to say a positive, if you will, attitude, which is to say that I think there's a win-win that can be had by both sides. And I'm very grateful to all of you for coming to be part of this conversation today. I'm very, very delighted that we had such a fantastic conversation. It's the beginning of a conversation. I will be calling on you again as experts to come back so we can continue this conversation. And hopefully somebody out there will be hearing us. Thank you so much, Matianga. I turn it back to you to close.
I'm mindful of the time, and so I don't want to, I think you did a great closing. I don't want to add anything else other than to just thank all of you. We've learned so much. And I think maybe right now where there seems to be sort of some calm in the waters is the space and time to be doing the reimagining that we're doing here. So thank you for your time. Thank you for your insights.
Thank you, everyone. Have a good evening and good rest of your day.